Okay. So this is case number 2401653 GC Calvary SPV1 LLC versus Tarina Tarena Ingram.
Good afternoon, Your Honor. Jeff Warber, P67124 on behalf of.
All right, Mr. Weber, good afternoon. Ma'am, what is your name?
Hello, Your Honor, Tarina Ingram.
All right.
Thank
And
you.
good afternoon to you.
Good afternoon, and thank you for hearing this case.
No problem. We have to do that. All right. And so today, from my understanding, I don't have a separate, submission with respect to this matter. It's my understanding that this is a Judge Arvant case and that there was a ruling on a motion to disqualify the judge, and she denied it for some reasons that she stated on the record. So I don't have a transcript of that. But you've asked me as Chief Judge to review the whole situation, pretty much de novo, as to whether or not Judge Arvant should be, in fact, recused from the case. So what is your basis that you're claiming that she should be recused from the case?
My basis is I compelled the motion, the date of the deposition, to compel to arbitration per the credit card agreement. I stated that I could compel arbitration at any time as long as there wasn't a default judgment or a trial started.
Okay.
So I did.
So this was a credit card debt
Yes.
with the plaintiff, Calvary SPV now. And you're saying that whatever the agreement was on the underlying debt involved an arbitration agreement.
Yes.
And you're saying that that agreement specifically said that you could request it at any point in time.
Yes.
Okay. So what is the basis for the recusal of the judge?
She denied the motion
Okay.
and entered a default judgment.
That isn't a legitimate reason to ask a judge to step aside. If it were, nearly every judge would be removed from every case at some point, because there will always be someone unhappy with a decision. Courts are built to make fair rulings, not to satisfy everyone's personal feelings. Allowing judges to be disqualified every time someone disagrees would make the legal system impossible to function.
So now you do know that there is a specific rule that outlines when a judge can be disqualified. So you're going to have to meet the standard under that rule. Now, typically, if a judge just takes an action on a case and you don't like it, that's an appealable issue to the higher court if you wanted to do that. But I'm not sure that means that she should be removed. You have to meet the standard for disqualification. So
Okay.
what, other than her ruling, what is it?
Well, it was unjust, and this lawyer attorney violated a lot of my rights. The debt was only $1,877. I never denied the debt, but this attorney never served me the original summons. Never served me.
Okay, but I can't, no, let me tell you what I can't do.
Okay.
What I can't do, because Judge Arvant is in charge of her rulings on
Yes.
her case. So I can't go back and change her ruling on
Yes.
the facts or the law. What I can do is decide if there was anything in the circumstances of what she did that would point to a reason to have her removed from the case.
She showed favoritism to the attorney from the
And how
beginning
was-
of the case.
How was that?
She made biased statements,
Such as?
when I told her that I mentioned that I never received the original summons. She said it didn't matter. You were put on notice with the alternative order that I signed.
Was that alternative service?
Yeah.
So what we call alternate
A
service?
second summons or alternate summons.
Oh.
Alternative order or
So it sounds like you're saying that she's basically saying if you didn't personally have it, that alternate service would satisfy it. So that's a court ruling. How does that show bias?
it's just statements that she made. She didn't everything that I said, she didn't hold him accountable for anything. She didn't ask him anything. Well, what steps did you take to serve her? she just showed him favor. He said that, Your Honor, you know me. I've been in your court before. He made oppressive statements, and during the mediation on the Zoom video, the judge is going to enter default judgment against you. He said it several times, like threatening and abusive and oppressive statements.
Okay, that's what he did, though.
Yes.
So here's the thing. The rule really sets out the kinds of things that the judge has to do. This is a pretty high standard to get somebody removed. And I understand you might not like the way she ruled on something. And it could be the case that you don't understand how she applied the law on some things. Because I will say this, and I'm not commenting on the validity of her ruling, but I can tell you that alternate service is usually given by court order when someone has had trouble personally serving. And so that is considered good service under the court rules.
Yes.
So I don't know if there was something wrong with her ruling there, but I can just tell you that pretty much is normal. And if you're following the rules, if the judge is doing that and you don't like it, the real remedy is to appeal it and see, not to me, because I'm not a judge, but appeal it to the next higher court if you think that there's something legally wrong with what she did.
Right.
Because, for this, you have to have real specific facts of how the judge would be biased or prejudiced. What is it she actually did other than just ruling on the motions or ruling on your requests or saying things like, well, it doesn't matter because you got alternate service. That's not a bias. That's really stating what the law says. Right. So you have to have a really good reason to show bias.
But it was my third motion, the third one. She already listened to the disqualified one and she denied that.
Right, and that's what you're appealing to me, is her denial of that.
I'm appealing the default judgment.
No, you are appearing before Judge Sheila Johnson, the chief judge of this district, because your request to have the original judge step aside was denied. The purpose of this hearing is limited. You are asking the chief judge to review that denial and decide whether the alleged bias you're claiming actually influenced the decision. You cannot use this hearing to re-argue your entire case or try to overturn the original ruling. That is not allowed here. Any challenge to the outcome itself would have to be made through the Court of Appeals, not in this review.
I can't do that. You have to go to circuit court to appeal her ruling on the set-aside default. The only thing I can do is say whether she should have removed herself or not. That's the only thing I can do, because I'm not sitting as an appellate judge. The appellate judges are at the Oakland County Circuit Court. So you could have done one of two things. Probably you could have asked her to reconsider her ruling. And if there's nothing new you're presenting, then she may not reconsider it. The ruling might be the same. Or you could, within the time frame that's allowed under the court rules, you could file an appeal up to the circuit court. And they would have to look at it and see if she did something wrong ruling on that motion.
She overlooked my complaints of the attorney violating my rights, my civil rights, and as a consumer. She overlooked that. She didn't look into that at all. She just overlooked it and just reprimanded me. She overlooked my rights being violated.
Okay, well, what rights were violated that caused her, that is showing some kind of bias?
Improper service. She didn't look into anything. The documents.
I thought we just went over the service part.
Well,
alternate service.
And then
might be good.
The oppressive statements that he made during the mediation. To me, that's a violation of the Federal Credit Consumers Act. That a debt collector or whoever's not supposed to make oppressive, abusive statements to collect the debt. He said it several times.
Well, okay. So I don't know what you asked her to do because I have no transcript. No one has given me a transcript of what actually occurred. And I'm really hearing this de novo, which means from the beginning, as if you never did it over there with Judge Arvin. So I'm trying to understand, what is it? Now, let's just say he did what you said, and he said some oppressive statements to you. What about that causes the judge to have to remove herself from the case because he made these statements to you in a mediation? Which, and let me just say this, normally, whatever's done at mediation, we don't know anyway. We don't really get involved with these.
Okay.
That's called a settlement process.
Okay,
So we usually don't even know what happened at the mediation and what, if there was an offer or not, and where they were, or how far the parties were apart, you know, what you offered them, what they said they would accept or wouldn't accept. We don't really know that because that's a settlement negotiation tool.
okay.
But if you're saying he said something that you thought was offensive, what was it that you asked the judge to do? What was she supposed to do? And how does that show she was biased against you or prejudiced against you? It's a very high standard. What you're asking me to do is remove her from that case and have it reassigned to some other judge.
Okay.
And that's the only thing I can do. I can't look at whether she was correct in her ruling on something because that's an appellate.
Okay.
That's an appellate issue. But I can say if something she did seemed like it was rises to that level of bias or prejudice against you, then I would say that motion, if you're asking for her to recuse herself, then that should be granted, and then I would have it reassigned to someone else. Either myself, it's a blind draw, myself or the other judge could possibly get it, but you would have to meet that standard just on that. So unless she said or did something that shows bias, we can't worry about the actual ruling itself.
Okay.
If you understand the difference.
Yes, I do. Yes. She made a few statements. I mean, this happened a few months back. I can't recall everything, but I did write some things down. Like I said, she was showing bias favor towards him when he told her, "You know me, Judge." And she made a comment about, well, some people just don't like to be served. I think that was biased. That wasn't just for her to say that because he never served me. So she was automatically.
When you say serve, you mean personally?
The summons, yes.
Yeah.
And she said, well, some people just don't like to be served.
Yeah, I've been through something similar, so I can relate. In my situation, someone named Chili Castro tried to serve me with a lawsuit that had no real basis, apparently to intimidate me and limit my right to speak freely. Situations like this happen more often than most people realize. That's why courts have specific rules and procedures, like alternate service, to make sure that no one can avoid being properly notified of legal actions against them. These rules exist to protect everyone's rights and keep the process fair.
Well, how's that bias though? That's just a fact that is actually, I heard there are people that what we call evade service.
Right.
And if people evade service, then they can come back and ask the court for an order of alternate service, meaning that you don't have to hand it directly to them.
Right,
but you
tack it
do.
on the door or something.
Yeah, you have to tack it. You have to do it certified mail and first class mail. Do things that would be reasonably calculated to get a person notice of a lawsuit.
And he didn't do any of that. He didn't do any of that, and that's what I'm saying. She didn't listen to me, period. She didn't look into anything. Okay. He didn't do any of that.
So you believe she was expressing a bias because she didn't look into
the case, the details,
and the details of the service.
Of me. Yeah, so what I'm claiming, I showed up, what I'm saying. She didn't look at anything. So he didn't do any of that. He didn't do anything. He just was deceptive and did all these tactics that he's not supposed to do, and he got away with it. And she empowers that. It's an article that I submitted to her about these debt collectors buying debts less than $2,000 for pennies on the dollar, and they're targeting minority and predominantly black communities. There's a justice report.
Okay, well, what would you like her to have done with the article and the fact that
I would have liked
they might be
look
targeting black
and listen, give me a chance and be just and fair, and not look at me and treat me like I'm a criminal because I experienced some financial hardship. I paid my bills. I had 11 credit cards that went bad. I paid them all. I'm down for 4. She didn't give me an opportunity to express and state my claims and show proof. She just reprimanded me, and she directly favored him and gave him the green light to do what he's doing. He never served me. He went for a gun.
Didn't we just say though that she ruled on the service and said that there was alternate service, so she didn't have to serve you,
and
they didn't have to serve you personally?
But he didn't serve me at all. He didn't
Well,
serve
you
it,
don't think
period.
you got it served any other way? It wasn't tagged, it wasn't sent by mail, and nothing?
No.
There was no certificate, there was nothing?
No.
And wait a minute, hold on, Ms. Werner, I'm gonna get right to you in a minute. So normally, the judges would look in the file,
Right.
and it will show how it was served.
Right.
You're saying this case showed nothing?
No.
Okay.
And there was a few documents that some server documented that they came out to my home.
Well, that's what we
3
looked at.
times. 2 times I was at work. They were work hours. I worked 9 to 5. 2 of those times was work hours. And then the third time, I don't know, I think it was on a Sunday or something, and I'm home. I'm out walking my dog. I'm sitting on the front porch. But the 2 times that was documented, that because I looked at the register, it's called register or something. I came up here. It's called register and accident something.
Yes.
Yes. And 2 of the documents that the young lady documented saying the windows was up, the lights was on. This was in May. And I was at work both of those times. I worked 9 to 5. I was working at restaurant.
In short, the original judge isn't stepping aside, and the default judgment will stay in place unless you pursue an appeal through the proper court channels. So Karen, it's time to take your complaints back to your corner. That wraps up today's video. If you enjoyed it, be sure to hit the like button. If not, feel free to hit dislike. But either way, leave a comment and subscribe with notifications turned on so you never miss any of my content. I'm Team Skeptic, and I'll see you in the next video.